really pleased to introduce you to the second panel this morning. Jeremias you already know, so I won't introduce them again. To the right of Jeremias is Erica Howard, who is Associate Professor in Law at Middlesex University. And Erica is published in areas of racial discrimination, freedom of religion, religious discrimination, and multiple discrimination. And she now has a forthcoming book, which is coming out in August of this year, on religious hate speech and freedom of expression. And to the right of Erica is Nicole Busby, who is Professor of Labor Law at the University of Strathclyde. Nicole researches and teaches in areas of equality law, human rights, and labor law. She's published extensively on employment, tribunal system, work-family reconciliation, constitutionalization of labor rights, and Nicole is a member of Scotland's Committee of the Equality and Human Rights Commission. And I will now turn to both of you to present, and again we'll go according to the program, 15-minute presentation.
Thank you very much, and of course thank you to Ania and Sarah for inviting me here. I've got a very long title for this presentation, which might be easy or might be more difficult, because if it's a long title, maybe you can pick things out that you particularly want to talk about. One of the things I want to look at is what has been said is the hierarchy of discrimination grounds because of the different protection that exists under EU law. Well, you do have the...
I do, sorry.
I did make a presentation. I sometimes make a PowerPoint presentation because I can put things on there that I don't want to say in too much detail or read out in too much detail. As we all, well, we've already heard, as we all know, Treaty of Amsterdam created competence for the EU to make directives, to take legislative measures on the other grounds of discrimination: racial, ethnic origin, religion or belief, disability, age, and sexual orientation. In 2000, we had two new directives, the Race Directive and the Employment Equality Directive. Sorry, do you want me to say? Thank you. There are the names of the directives. But the directives do not cover the same ground, or the same areas. The Race Directive prohibits discrimination on the ground of racial and ethnic origin. The other directive covers the other grounds. But there is a difference. There's, in a sense, three differences between the directives. The Race Directive covers a lot more areas. The Employment Equality Directive only covers employment and education, occupation, while the Race Directive goes a lot further. Covers social protection, social security and healthcare included in that, social advantages, education and access to and supply of goods and services. Then the Race Directive has put a duty on member states to designate a body as an equality body. That is absent of the Employment Equality Directive. And you could say that the Race Directive also is stronger in the sense that it only allows justification of direct discrimination in very restrictive circumstances, general occupational requirements and positive action, while the other directive, the Employment Equality Directive, provides exceptions for churches with a religious ethos. It provides for reasonable accommodation for disabled people. It provides, as we have already heard, for justification of direct age discrimination, and it has a general justification clause in Article 2.5. There is a proposal, and I'm sure you all know about this, to extend the protection under the Employment Equality Directive to all areas covered by the Race Directive. But that proposal has not been adopted yet. It's only been around for nearly 10 years, but it seems to have been stopped somewhere. Maybe the unanimity here is a bit too far. But the EU law, you can say, creates thus a hierarchy of discrimination grounds. The top is racial discrimination because it covers so many more areas. In a sense, it's at the top of, it was a directive that was adopted in record time, just over a year after the community got a competence, and also within 7 months of a proposal being published. And I think it was basically political expediency, strong political will at the time. One of the things was the elections in Austria, where Jörg Haider's Freedom Party, extreme right-wing party, was elected as part of the government. And the member states wanted to show that they were very much serious about combating racism. And there was also probably some argument in the fact that there was an enlargement in the making at that time, and they wanted a strong anti-discrimination acquis. And then there was the World Conference on Racism, against Racism, Racial Discrimination, Xenophobia and Related Intolerance, which was in Durban in 2001. So there was a political will, and maybe you can say, well, this political will, maybe they shouldn't have had the 2 directives, but at least because of the political situation, we have a race directive and a protection against race discrimination that goes a lot further than the other grounds. And maybe if they were all in one directive, we would not have got there. I think if you look at the hierarchy, H is at the bottom because direct discrimination can be justified. What about the other 3 grounds? I have put them in a certain order, and I think disability could be seen as maybe slightly more higher in the order because there is the duty of reasonable accommodation, and on the next slide there is an example of a duty of reasonable accommodation. Maybe not in work, but it is a reasonable accommodation. So that duty exists for disability. You have to make a reasonable accommodation for disabled employers. Now some people said, why? Why just for disability? It could be useful for other grounds, religion and belief, age, or maybe for all grounds. And the duty actually was started in the US as a duty in relation to religion. Then it spread to disability as well. And in Canada, all grounds are covered. So there could be a way of doing this. Now, I wonder if religion and belief should be at the bottom of those 3 because of the recent judgment, but I will come back to that in a minute. One of the things that and we've already mentioned a lot of it, so I won't go into too much detail. The next couple of slides have cases on it where I think the court has shown its willingness to give a purposive and expansive interpretation to the directives. You've already heard about Mangold. The court has also held that compulsory retirement ages are under the directive and thus have an objective justification test. We've mentioned discrimination by association in Shea. That is for direct and indirect discrimination. Direct discrimination based on Coleman, where a mother of a disabled son was suffering detriment at work because she had to look after him. We have mentioned Shea. Now Shea was not only saying that indirect discrimination by association is covered, but it also clarified the interpretation of the concept of ethnicity, saying that it had its origin in the idea of societal groups marked in particular by a common nationality, religious faith, language, culture, and traditional origins and background. Now, I was quite surprised to see in here the religious faith, because you wonder if that's falling under the race directive. But its group, the religious faith plays a role in what an ethnic group is. Terrain was already mentioned. A policy where members of certain racial or ethnic groups are not considered for employment is directly discriminatory. What Terrain also established was that you can take a case without an identified victim, if that's possible in national law. It also said that what in Terrain, the director of a small company who fitted garage doors and security doors said on the radio, I don't want to employ immigrants because my customers don't want them on their premises. The court said that was enough for a presumption of discrimination and thus for a reversal of the burden of proof, which was also quite important. The same issues were sort of mentioned for the Employment Equality Directive in Accept. Thank you. I think this is quite an important development, and the court has said that in Ring and Werger that you have to explain disability in conformity with the convention. Now, I put the definition of the convention on there because I don't want to read it out. But in a sense, you could see it talks about with interaction with various barriers, which suggests that the convention is going more towards what they call a social model of disability, rather than a medical model. A medical model say the disabled person is a medical case and something wrong, and we have to approach it from there. The social model looks much more at the barriers that society throws up for disabled people. It's the only convention that the EU as such has signed and ratified. So, but it's interesting that they have that definition, which will help, I think, in EU law. The next slide has some cases on sexual orientation discrimination. In a sense, basically what the court has said, if you recognise same-sex relationships in a registered form or a marriage form, then you have to treat them the same. They have said it's up to the member state if they want to do that, but if they do it, it has to be treated the same. One of the cases that, thank you, one of the cases that I think seem to be less extensive is the Paris case, in the sense that there the court seemed to have rejected multiple discrimination. Now we have the speaker talking about multiple discrimination later on, who's much more of an expert on it than I am. But it seems, the court seemed to say, if you cannot establish discrimination on the basis of each of the grounds, in this case it was age and sexual orientation, then no new category of discrimination resulting from the combination of more than one of those grounds may be found to exist. And that brings us to Ashbita and Uganui. The cases on the headscarf. The cases are quite short, actually. The Advocate Generals were much more expansive, and the Advocate Generals were also much more opposing. In the two cases, they seem to come to quite a different conclusion. Is this an expansive interpretation of the directive? Thank you. Maybe in some ways, but in a lot of ways, maybe not. The referring questions are on the next slide, but I'm sure you're all familiar with it. Basically, it was two women who wanted to wear headscarves at work. When they refused to take them off, they were dismissed. The Belgian court basically asked, is it direct discrimination when you dismiss somebody because they don't want to take a headscarf off? And in the Belgian case, Ashbita, there was an internal rule saying you cannot wear visible political, philosophical or religious signs in the workplace. The question in Bugnauie was slightly different. There they asked, is it a general determining this occupational requirement if a customer asked to be served by somebody without a headscarf. Positive aspects. Religion was explained in a very wide sense. The court said it should have a broad interpretation. The court basically seemed to accept fairly easily, without any much discussion, that this was within the scope of the directive. The court said there was no direct discrimination in Ashbita because it was a rule that covered any manifestation of beliefs without distinction. There was no evidence that the rule was applied differently to Commission Ashbita. So there was no direct or indirect, so no direct religion or belief discrimination. About Bugnauie, it said, we're not sure if it's direct or indirect. But in both it said it's up to the national court to decide whether it is or isn't direct or indirect. Then it went on to give a lot of instructions to the national courts. Basically, they said, and Colm has already mentioned it in Article 16 of the Charter, is the freedom to conduct a business and the aim of having a neutral workplace falls under there. It's a legitimate aim. When it looked at whether it was appropriate and necessary, it says the ban has to be generally pursued in a consistent and systematic manner. It should not make a distinction between different religions or different religious, philosophical, and political beliefs. The rule should be limited to customer-facing employees, and the employer should consider whether the employee could be moved to a job without contact with customers. In relation to the general occupational requirement, the court found, and this is Article 4.1 of the Directive, occupational requirement depends on the nature of the job and the context in which it's carried out. A Jewish school requiring a teacher of religious education to be Jewish is a general occupational requirement. The Pope to be a Catholic is probably a general occupational requirement as well. In the French case in Bounaoui, the court decided that the wish of a customer not to be served by or have work done by somebody with a headscarf was not a genuine occupational requirement. And I think they just basically followed the Ferrand case in this. So what does it all mean? Very good question. And I was at a session at UCL about this case on Wednesday where Colmar was also talking. And as many opinions as there are people, I think, about the case. And I think maybe you can say that there's no right for employers to ban headscarf or symbols as such. If they ban something, if they have it, they have to include everything. And the court seemed to suggest that you have to ban religious, philosophical and political symbols. So there are some examples of these sort of symbols. So you have to ban skull cap, crucifixes, turbans, badges with political slogans, etc. I think it's also clear that it will be difficult to justify restrictions on clothing for those employees who do not come into contact with customers. And one of the things, and I think Hubert already said that, there is some obligation on the employer to try and accommodate the religious employee, which I think is an important issue. But one of the things that I would say, and this is my personal view, that the court seemed to be rather easy on the justification of indirect discrimination. I'm not sure that it fits in with what it did on the other grounds, because there they always have had a strict justification test. The court, to me, a justification test is a balancing test. The court seemed to put this Article 16 to conduct a business on one side, but did it really look at the freedom of religion? The Charter also has, as we already heard, a prohibition of discrimination. The Charter also, for instance, says every worker has the right to working conditions which respect his or her dignity. Article 31. And Article 30 also says, the Charter, every worker has the right to protection against unjustified dismissal in accordance with union law and labor practices. Maybe the court could have had these in the balance a bit more. And one of the things that I find worrying is the fact that they gave a strict justification test, and does that fit in with EU law? They seem to say that religion or belief is different from other grounds and should be treated differently, and that's where I find it quite difficult, because I think giving more discretion to the member states, using a different test might lead to levelling down on the other grounds. So that's really what I want to say. I think in relation to what the subject of the conference is, that we definitely have to try and get the proposal adopted. At least then we have more protection on the other grounds, apart from racial and origin discrimination. But I just wanted to give you a quick overview of the court's decisions.
Thank you very much.
Thank you, and thanks very much for the invitation to speak to such an informed group of people. What I'm going to say is quite policy driven as much as legally driven, because I'm looking at an area, work-family reconciliation, which really sort of borrows from all possible sources, so it's quite broad-based. I think I'm obliged to say, because Ania mentioned in the introduction that I'm a member of the Scotland Committee of the EHRC, I think I have to say that anything that I'm going to say is a reflection of my personal views and not the views or thoughts of the Commission itself. So, thinking about work-family reconciliation, work-life balance, it's been, again, the terms here are used interchangeably. I think the Commission term that we see most commonly used, the EU term, is work-family reconciliation, so I'll probably stick with that one. We have to go back to the beginning of the EU, the origins of the EU, the historical beginnings, to really appreciate how the law and policy in this area has developed, and to understand why we are where we are today, and I'll say a little bit about that at the end. So the law and policy making capacity in this area relates to those areas and objectives in which the EU obviously has a specific interest, or we might say legal competence in legal terminology. So we're looking at women's labour market participation and gender equality as they affect the smooth operation of the labour market. That's really what's driven development here, and I'll come back to that as I go along. So the legal and policy framework providing for the accommodation of unpaid care alongside paid work, be it for children, elders, disabled or chronically or terminally ill family members, is shaped by this beginning, this origin. And that's been a difficulty. That provides certain challenges, particularly in the context of where we are presently. So my main argument in what I'm going to say this morning is that despite the great strides forward that have been taken by the EU, undoubtedly, in the development of a legal and policy framework, progress has been thwarted by the lack of a cohesive and coherent overarching strategy in this area. And that covers everything, I think, that has happened. And this lack of a clear and sustained commitment to resolving the conflict that actually arises from trying to encompass issues related to care within pre-existing structures and institutional arrangements has caused progress to stall in this area, undoubtedly. And this perhaps arises from a lack of political will on the part of the institutions themselves, but it certainly comes from a failure of the member states to reach agreement on some of the key issues. And we've seen that become increasingly difficult as time has gone on, and as the boundaries, if you like, have been pushed further and further away from the economic origins towards the kind of social underpinning, the development of social rights. And underpinning all of this is the mismatch of the aspirations and objectives of the social partners themselves, which obviously are very important in this area because we're looking here in the main at employment law and policy. So the trade unions and the employers' associations have a say in much of the resulting legislation. Recent developments may provide a way out of this. I'll finish on a note of optimism when I get to the end. There is scope to extend the EU's legal competence in the area through the deployment of certain provisions of the Charter of Fundamental Rights, Article 23, Article 33, so gender equality and the recognition of work-family reconciliation itself. And the Commission has recently invigorated its own interest in the development of law and policy under the new pillar of social rights, which was mentioned already this morning, but I'll come back to that briefly at the end, because there could be something quite exciting happening there. So the plan really, what I'm going to say is a quick whistle-stop tour through the historical development of the relevant framework. I'll focus on the policy objectives and their mismatch with adopted actions, and then consideration of the current position, and in conclusion, I'll look into the perhaps UK-less future of EU law and policy on work-family reconciliation and its relationship with equality. So beginning very briefly, the World War II origins of the EEC, core aims, of course, and objectives centred on the establishment of a common market, one that would function in a way that promoted interstate cooperation in the pursuit of economic growth. So this pooling of resources was viewed as the best way to create economic wealth and preserve and strengthen peace and liberty, preamble of the Treaty of Rome. The protection of workers at this stage was inconceivable, as the EEC was market-making, not market-correcting. The protection of workers comes in, as we know, later on. Underpinning whatever mention or thought was given, and very little I imagine, to the employment provision or the employment dynamic of this was the standard male worker model, which epitomised the normative ideal of full-time, permanent, unencumbered individual, and any labour market policy in the early days was based on this model, with women, due to their care commitments, unable to comply with the normative ideal, the normative standard. So this process of the othering of women, particularly mothers, has had a profound effect on women's relationship with the labour market, not just under European law, in general, in domestic legislation as well, in the member states. Traditionally, women's participation in the formal economy was patchy, and it's been subject to a history of what you might call instrumentalisation at the hands of policymakers. So women are used in times of labour shortage and discarded through restrictions in state nursery provision when men are available, i.e. when they return perhaps to war or whatever. So we see that very much in the historical development. So women's attachment to the labour market has always been closely related to the level of state provision for unpaid care, be it through availability of nurseries, care homes, general health care, work welfare regimes, etc., as well as the availability of jobs which can be, or around which care can be accommodated. But the EU has no competency in social welfare provision. So in work-family reconciliation, we see a tension there immediately. The goal, of course, is to influence social behaviour. If we're talking about work-family reconciliation being underpinned by this desire to see women's participation rates in the labour market increase, we're talking there about influencing social behaviour. And the relationship, as I say, between women's paid work and state provision has meant that women have become used to the allocation of their time for paid and unpaid work being manipulated through public policy, be it through benefits, welfare provision, or employment policy influencing employers' behaviour. Men have not had the same history of their behaviour being influenced in this direct way, and any attempts by policymakers to instrumentalise men's employment patterns in relation to their family arrangements have been viewed with hostility traditionally, and accusations of interference with individuals' private lives. So I'll come back to that point later, because I think that's really important for where we're going in the future and where we might be restricted in that. So there are broad economic concerns. When we talk about EU work-family reconciliation, we have to bear in mind these broad economic concerns, the free movement goals, full employment, gender equality at work, certainly very important in all of this, and we see it coming in through the Treaty of Rome, Article 119, the early directives on equal pay and equal treatment, and now the recast directive 2006. And we see policy and law on the reconciliation of paid work and family life beginning to come in to the framework incrementally. So over time, the EEC transformed into this larger union, widening geographically to include new member states and deepening as a new legal order was created. And within the new EU, the significance of workers and their families gradually received greater attention from policymakers, although unsurprisingly, concern for working carers, when attention did arrive, was patchy and inconsistent and constructed along with broader social goals as side issues, really, to achieving greater economic integration. So within the EEC and later the EC, reconciliation of work and family life was developed only as a necessary adjunct to broader policy concerns, primarily gender equality and economic agendas such as free movement, and later as part of a growing allegiance to human rights discourses. More recently, it's been subsumed within the 2020 strategy of full employment. So it is still there as a kind of, very much underpinned as a kind of economic instrument, if you like. Significantly, at no point in the history of Europe has work-family reconciliation been a core policy goal in its own right. I think we have to recognise that. We then move to what's been called work-family reconciliation, which is EU regulation aimed at enabling parents and others to manage the conflicts inherent in juggling the demands of paid work and care-related commitments. And that's historically linked, as I've said, the goal of gender equality with the development of social policy under the banner of work-family reconciliation. So equal opportunities was really the kind of underpinning rationale, but there are limits, we know, in procedural equality. by the 1990s, changes in the labour market itself and to family formation and social arrangements had led to a series of demographic, economic and fiscal challenges to the member states' welfare systems. And this catalysed EU attempts to respond by legislative and policy means. So that Lewis has said the growing willingness to address family care issues insofar as they impinged on labour market participation, especially of women, was as much a part of these considerations as the equal opportunities agenda itself. But women workers and the way in which they sought to combine paid work with unpaid care commitments brings a number of specific challenges to this standard worker model. And we see then through the 70s, 80s and still to this day the development of a series of cases on part-time workers and their assertion of their right to equality with full-time equivalents. And these cases were brought by women workers on a whole range of issues to do with various terms and conditions of employment. From Bilka Cowhouse up to the present day. But there was really, in a lot of the early cases, although they were very important in setting down some of the founding principles, no clear consideration of the needs of family or the domestic burden itself. It was all about how we might incorporate or encapsulate the needs within the workplace, within the working environment. And a particular difficulty arises then in issues related to the pregnant worker. And we see some very progressive decision-making by the CJEU or ECJ in the early case law on pregnancy, which shaped lots of domestic systems subsequently. So we see DECA, where the court held that the absence of a male comparator in relation to pregnancy-related discrimination was not capable of defeating the claim. You know, pregnancy is unique. You don't need to have a male comparator in order to assert your right to equality, to gender equality. And then a whole line of cases within that vein. However, I'll skip a little bit here. What we have seen criticised in some of that case law is this adherence to perhaps outdated but very traditional notions of motherhood. So we've seen motherhood protected in a way, which I don't think is particularly useful. I don't mean around the pregnancy, and I don't mean around the time immediately following the birth, but the relationship between pregnancy and parenthood has become enshrined within the case law and within some of the legislation and its interpretation. And I think that is a thing that we really now need to unpick and think about a bit more creatively. We've seen a very good recent case, the Roca Alvarez case in 2011, where time off ostensibly for breastfeeding was really to provide care for the baby, and the court decided, yes, it should be extended to eligible male workers, not exclusively the domain of women workers. So we have seen a development there in the case law as well. In terms of working parents, we have the Parental Leave Directive, which recognises that care need not be the exclusive responsibility of women by giving equal rights to both parents, but its reliance on pre-existing national welfare systems left the status quo pretty much intact, preventing it from being a policy leader. So the rights provided by the directive were never really going to challenge the division of care at the household level, largely because it's unpaid. There are other things wrong with it, but the main problem with it is that the leave is unpaid. And at the beginning, it was transferable, or there was no use it or lose it provision. That was amended subsequently in 2010, so that there is a 1-month period under the directive, which is non-transferable. So men, then, if they don't take it, will lose that entitlement and can't transfer. But there are still these dominant policy preoccupations. In terms of care for elders and disabled dependents, so dependents or care that might be provided for those who aren't children, we've got very little at the EU level. Nothing firm in legislation. We talk mainly about mothers, pregnant workers, motherhood, and parents generically, although no clear rights for fathers. So beyond these ad hoc, unfocused and disjointed legal developments, there has been over the years, I should say, a steady trickle of soft initiatives by the Commission and the Parliament seeking to raise the profile of, and in the case of the latter, encourage greater policy support in relation to workers with elder care responsibilities. So there have been attempts made to try and encapsulate or incorporate elder care in particular, partly because of the demographic challenges that it presents into the European acquis. Overall, though, it's clear that at present there's still little appetite for change in that particular area, and it's for the most part has been perceived as a policy matter for member states, but as I say, there will be some optimism at the end of all of this. Just to conclude, and then I'll come on to the future very briefly, there's no legal competence for the EU in social welfare provision, and that has, I think, been unhelpful in the way that you might join up the sorts of provisions that would helpfully be coordinated or joined up for some overarching strategy in this area. The existing care framework has developed piecemeal in a reactive, not proactive way, and reflects the formal equality model that underpins the EU's legal framework generally. Much of it is based around, as you might expect, the needs of employers, not the needs of workers. I think the strategy is disjointed due to some competing rationales and policy goals. And of course, where we have EU in crisis, you know, the kind of danger alerts, so we've got Eurozone issues, the sovereign debt issue, the existential crisis, Brexit, and so on. Social policy has always been compromised in difficult times, and we've certainly seen that in recent years. But, and here's the note of optimism, the Commission has recently adopted a proposal on work-life balance, as recently as 26th of April 2017. Jeremias mentioned it in the earlier session. It's part of the European Pillar of Social Rights, which was launched alongside it in April 2017. And the pillar itself has three main categories: equal opportunities and access to labour markets, fair working conditions, social protection and inclusion. So all of those really give very good rationale for doing something in the area of work-family reconciliation. The institutions will share joint responsibility for its implementation, and an online social scoreboard will track progress of the European Pillar of Social Rights. I see some of you smiling at that. Now, under that provision, there's a proposal on work-life balance which includes a proposed directive. So this looks quite good. The proposal on work-life balance is intended to address certain gender inequalities, so it's still focusing very much on women's employment rates and increasing those so that they at least come closer to those of men. At the moment, women's employment rate is 11.6 percentage points less than that of men. So there's a recognition that the EU needs to modernise its legal framework to ensure a better balance between between work and family life for both women and men. So we begin then to turn the spotlight a little bit on men and where they might participate more in family life and away from women and their participation in the workforce, but still underpinned by looking at how we might increase women's participation rates, so coloured very much by that. And it's still very much underwritten if you look at the policy documents by a business case, very much based on that imperative. What does the directive propose? 10 days of paternity leave following the birth of a child, so paternity leave for the first time in EU law, unpaid unfortunately, but improvements to parental leave provision, 4 months to be paid at sick pay level, which is currently unpaid, remember, a take up until the child is aged 12, it's currently 8 years old, and 4 months non-transferable from that 1 month position. So 4 months use it or lose it for fathers, which I think might do quite a lot. A new right to 5 days of carers leave per year per worker, paid at sick pay level, and new rights to request flexible working arrangements and better protection against discrimination where workers assert their rights. So there is some cause for optimism. There are things wrong with the directive or the proposed directive. Is it going to change anything? It's got to clear all those legislative obstacles before it gets anywhere. So we have to see it move through the EU legislative cycle. And of course, when a proposal to amend the Pregnant Workers Directive was made by the Commission previously, it failed at the Council stage. So whether or not these provisions will be met with any favour, I think we have to be realistic about that. It failed, I should say, the Pregnant Worker Directive proposal failed on the grounds that there was too much diversity between member states, but it's difficult to envisage a time when that diversity will not exist. And even if it does succeed, I think the shift away from the focus on mothers towards parents is very welcome, but there are still high levels of pregnancy discrimination across the EU. And the proposed paternity leave is not compulsory in the directive as it stands currently, so there may be difficulties in persuading fathers to engage with care for the reasons that I mentioned earlier on. Remember, unlike women, men are not used to their working time being instrumentalised by the state to fulfil overriding objectives relating to the reconciliation of unpaid care and paid work. So that may be a real hurdle that has to be overcome, and I don't know how you begin to do that unless you make it compulsory, and then we run into difficulties with interference in private life. So I'll leave it there. Thank you.
Thank you.
Right. Thank you very much indeed for these two really interesting and stimulating presentations. Again, three thoughts to offer. First one is a heretical thought, which I'm going to offer but then discard. The second one is more sort of about the political background, which I thought was a really interesting element of Erica's presentation. And then I guess I've resisted it thus far, but I'll have to talk about our old foe, Article 16 of the Charter of Fundamental Rights. You can already go for lunch at that point. So, starting with a slightly heretical thought, particularly I think in Nicole, your presentation, you sort of return to this deep tension, which I think is already in your 2011 OUP monograph, which has been very extensively and extremely usefully deals with some of these issues, about the problem for the EU in dealing with work-family reconciliation because of the underlying competence issue. The fact that actually if you want to really tackle this problem, it's not just a labour law issue. It's actually a much broader issue of saying, well, it's not just about dragging women into the labour market as an additional burden on them, it's actually completely rethinking overall how we organise care, who takes responsibility for it. And in one sense, the EU is never going to be able to tackle this, short of treaty revision and much more powers and a strong loss of member state sovereignty in this area. And so that's sort of, and I suppose that the worry then is that there might be this danger of entrenching a lot of these problems which we see in terms of the traditional standard model and the sort of solutions based always on that standard model within EU law. So one way of doing about this, and thinking here about Juncker's plan earlier this spring about the 4 different options for the future of the EU, well, one of his options was that the EU should actually completely pull out of this field. And actually maybe this whole area shouldn't be for the EU, and we should give this all back to the member states, and we should just leave it completely up to member states. Now, that's a superficially quite attractive idea, because you could say, well, actually, if this needs both the labour law coordination, but it also needs various bits of social security, sort of provision, state provision element, if we leave it all to the member states, maybe they can sort of really rework the bargain. I say it's superficially attractive, because of course the problem is that any remaining bits of EU law, you would never be able to insulate member state provision from EU law simply because of the constitutional dimension, because of the supremacy with which all other bits of EU law have been endowed. So that's why it's a superficially attractive idea to say, well, we need both of those together, let's give it to the member states. In reality, I think even for Juncker's plan itself, that was a bit of a red herring that was more thrown out there than anything that was ever meant to be a serious idea of devolving these competences. So what else instead? We've still got this lack of coherent structure, this lack of political will, which I think emerges very much as one of the key themes out of actually all the 4 papers we've seen this morning. And so I found this really interesting in Erica's perspective about this moment of shock, which we seem to have had in the early 2000s. There's a confluence of interesting figures. And that led me to wonder whether maybe, just maybe, we're actually back at a similar sort of juncture, at a similar sort of crossroads. So Jörg Haider is dead, but Orban, the Kaczynski brothers, lots of similar figures actually in other member states playing that sort of role. Enlargement, again, it's now quite a while ago, but we've got Brexit. which in one sense actually is similarly going to rejig the cards in a way. Struggle to find an equivalent thing for the Durban meeting, but if you look at just how the Commission is pushing this whole social pillar thing at the moment, there's a real sense, I think, of political urgency to do something, or I suppose more cynically, at the very least, to be seen as doing something. And so if we go right back to where we started in the morning, this idea about contingency having been a problem in all of this, the politics, but it also means, as Ania said very clearly, that there is the possibility for change. And we see this in the proposed directives you discussed, and we also see this in the broader consultation process with the social partners, which the EU has now launched. And I think that, in a sense, might mean that there's a real sense of urgency now to think about the coherence and to push it right now, because that process is not going to run for a long time, but it is running now, and it's through the social partners on the national and the European level that there might be a real sort of window of policy opportunity. And that might be the opportunity to push for some of the coherence, push for some of this realignment that we're talking about. But, with again one caveat, that has to make sure it's about the levelling up. Right? And there's one danger that if we pursue coherence, then we say, okay, we've got this, I really like your sort of, tiered structure of the equality rights. There's one real danger that we say, okay, let's create coherence through a smallest common denominator. So I think there's one sort of caveat attached to my sort of, let's use as a policy opportunity, coherence, to say coherence, levelling up, rather than levelling down. Finally, thinking about the courts, and particularly about Article 16 of the Charter. So I really struggle, and have been struggling for a while, with Article 16, and not just because of the sort of the general economics approach. I think there's a more deeper, fundamental sort of coherence problem. So my problem with Article 16 that starts playing out in more and more of this case law is the following. In substance, it's really incoherent. It's fluffy, we don't know what it is. And yet, that fluffiness then gets supercharged with the normativity of a fundamental right. And that's what leads to all this mess. So let me quickly explain those two things. First of all, the sort of the fluffiness of it. But if you look at the guidance notes to try to work out what Article 16 is, first of all, it sends you to bits in the case law that don't even talk about Article 16. If you then sort of look around, you find a couple of basic cases where freedom of contract, business freedom, gets used as sort of throwaway remark, only in order to be qualified instantly. Right? It's a case about freedom of orange producers, things where they say, well, of course, there's an underlying principle of economic freedom, which EU law will then put limits on. In the internal market, again, we don't have any kind of general business freedom. You have a certain limited cross-border freedom, but you look at something like KEC, the court makes it very clear that even in the sort of pure internal market law, there is no such thing as an untrammeled freedom. General principle, common constitutional traditions of the member states, there are vastly different conceptions across the different EU member state legal orders as to what we mean by economic freedom, let alone the then sort of supercharging of freedom of contract. We've got completely different approaches in the sort of civilian legal systems that's based on autonomy, supposed to say the common law, where it's much more based on market transactions. So the content of Article 16 is really fluffy, and yet it now gets supercharged with the normativity and the sort of entire machinery of EU fundamental rights protection. As long as it's just a sort of happy general principle, well, the court can mention it and then discard it and not worry too much about it. The moment you have it as a fundamental right in the Charter, you can say there's been an infringement, and any infringement of that now needs to be justified, and we need to run through proportionality. And that starts to worry me. Because yes, there are lots of easy cases, lots of cases where traders try to use Article 16 and the court just sort of says, don't be silly, right? It's the likes of Ryanair saying the passenger rights stuff is a violation of Article 16 right. But there are other cases where the court starts to seriously engage with it. And you see the court actually running through the full-blown proportionality analysis. And that becomes very unpredictable in terms of the outcome. Even worse, you look at cases like Cocopelli, where actually the Advocate General and the Court of Justice, applying the same test, using the same factors, come to opposite conclusions on Article 16. And so I think if we already start with a sort of incoherent mess, as it were, of EU equality law, and then we pull the pin out of the Article 16 hand grenade and chuck it in for good measure, I just don't think a lot of good will come of that. Thank you.
Should I also take some questions, or would you like to say something?
Can I just say a very quick thing, which is about the social partners in relation to the directive. The social partners, so the Commission has taken back the power to propose the legislation itself, because actually an attempt to broker a framework agreement between the social partners in this area failed just recently, actually, just in the last few months. And that was because of the employers' side's reluctance to change any existing legislation. So although trade unions were quite willing to amend the parental leave directive, the employers' side said absolutely not. They didn't see any need to change existing legislation. So I don't have much optimism about the social partners' role or any attempt there in this area, which again makes it even perhaps more uncertain than I think.
So thanks for all of those interesting contributions. It was sort of struck me that the speakers, you pointed to significant legislative proposals for the maternity reform of the maternity directive and for the extension of the equality directives in 2008, neither of which ultimately were adopted, and albeit the extension of the equality directives is still on the table and still being discussed, and both confronted the difficulties of reaching political consensus in a much larger EU than the point in time when some of the earlier legislation was adopted, and also in very adverse economic circumstances. And I suppose one of the things that appears to be more in discussion now in thinking of future developments is whether a way to break the logjam is to go down the route of enhanced cooperation of smaller groups of states progressing by themselves, and in a way you slightly see an echo of that in the European Pillar of Social Rights, which is proposed initially for Eurozone states and others if they wish to take part. And instinctively, I suppose there's a bit of a resistance to that in an area where we're touching on issues of fundamental rights, where we tend to assume that implies and the experience historically of European social policy, we just had the one period when the UK had opted out of social policy, and it was sort of not seen at the time as a desirable thing. But do we need to confront a kind of a reality that if we're going to be able to make significant progress in the development of law and policy, we might need to be more open to the possibility of sort of multi-speed developments in these areas?
Carl?
Yeah, two things. I just want to very much agree with Mark. I think my view is that the politics that led, for example, to the 2000 Equality Directive, the political situation has changed dramatically, and states have realised the mistake they made in 2000 in allowing a sort of pan-European, allowing sort of strong equality protection to develop at a pan-European level. I don't think they would accept that nowadays, and this is the reality that I think haunts the discussion on the 2008 draft directive. And I think therefore we need, if anything's going to move forward there, and I've been hearing from the Commission a lot about how the 2008 directive, I've spent the best part of 10 years hearing how the 2008 directive is draft directive is very close to being implemented. But I mean, it's not. And I think there needs to be a very serious discussion there about how to move it forward sort of at different levels. On the Article 16 point, the development of Article 16 as a fundamental right is fascinating, because of course it owes its origins to the Nuremberg laws. It was originally inserted in the German Basic Law and other national constitutions to guarantee constitutional right first emerged in the European scene in the 40s and 50s as a non-discrimination provision has over time mushroomed at national level in some countries, and now is mushrooming at EU level, into a general right of business autonomy through a way that I find is quite extraordinary. And actually, you could argue, especially in the equality context, is actually undermining its original rationale. And there's a real, and it's been a slightly unexpected side result of the Charter, which is that there's a constitutionalization of multiple different aspects of EU law that, in my view, is highly questionable. The notion that businesses have a right to regulate their own affairs, a fundamental right, is not common to the constitutional traditions of most member states. It would be incomprehensible in certain constitutional traditions. It's not something that's inherent to the human rights architecture. It's not something that finds a basis in the ECHR. And I find the court sort of flirting with the idea that this right does now exist per se the Charter. I find it a very, very problematic development.
I do agree that it's a very scary development in that sense. And yes, the Article 16, somebody on Wednesday said the court found his Article 16 and decided, oh, that's a good idea, we'll hang up our decision on Article 16. I don't know if that's what happened, but I do. But I do share your concerns about Article 16. About your question, or your sort of remarks in question. I think we should still see probably the 2000 directives as a minimum level, and I think you mentioned levelling down in different ways. I think that's what we should be really careful for. I think maybe we should celebrate what we have and make sure that we don't go back on that. So it's, and the multi-layered, yeah, and maybe that's the way forward, and maybe that's, if we do it in different sort of different steps for different people, then maybe we will get to that better protection everywhere in that way as well. But it's not easy. I think we should stick to that minimum protection anyway.
Yeah, I agree with the point about minimum protection, particularly in the current situation. Of course, the political context has changed significantly since 2000, and will continue to change. A twin or dual track development, yes, I mean, it's a possibility, and you're right. Yeah, the eurozone has been sort of picked aside from the other member states, and harmonisation isn't any longer a name or a goal or whatever. So why not? My worry would be that gender equality is compromised if we go to different speeds in different countries. It would enable some of the cultural diversity to be incorporated or given thought to, but is that what we want? I mean, I just would worry about the gender equality goal and the way in which that is enshrined so deeply in much of the acquis. I don't know how that would work, so I think that reservation.
Yeah. I would like to make a comment. I think I fundamentally agree with you that the political situation has changed. But I would not go so far as blame what's happening in Hungary and Poland now on the emergence of a social pillar. I mean, the social pillar, the preparation for the social pillar, started already when the current commission came into power, and there's a clear link with the allegations that the social dimension of the whole European project has been forgotten, in particular in light of the austerity measures, and that's a clear driving force. And Juncker himself is clearly committed more than previous presidents of the Commission to get the social back on the table. At the same time, I mean, Orban and Poland do show us one thing very clearly, and that is that with the rule of law, we only have the nuclear options, and that really is a political process, and it has also nothing to do with the social pillar, but it doesn't make life easier. At the same time, Mark, if you want to go for enhanced cooperation, I wonder whether or not you don't go down too narrow a road. Republic, for instance, consistently got recommendations to increase this, and this has helped a lot women to participate into the labour market. And at the same time, a warning. I mean, you can blame a lot on the member states, but at the same time, you should not forget that there's a co-legislator, and the maternity leave directive never had any chance when the Women's Committee of the European Parliament put a wish on the table which was totally unacceptable even for the member state with the best protection system in Europe, and that's what they should realise. And I think that's also a very clear message which they need to keep in mind when they will start discussing the work-life balance proposal. There are a lot of interesting elements in there, but if the social partners already cannot agree, and we are currently in a situation where the competence is questioned more and more by member states, we'll go back to it after lunch, then you need to be realistic in what you ask for, and by over-asking, you might not even get the positive elements, which is at least the paid level which is now indicated. It is sickness, but sickness in a number of member states means total salary, 100% during 1 year, and that's very important. And people need to keep in mind, we had the working time proposal once on the table. It never got adopted because no deal was better than a bad deal. And what did we end up with? Instead of having one opt-out for the UK, we got 90 member states de facto applying the opt-out, and we're currently still there. And at a certain moment, there were reconciliation provisions, including during the process, but we lost everything. We lost the baby, the bathwater, everything, and it's still not there. And there is really no appetite at EU level at this moment to open up the working time at any stage, which in a way brings us back to a legal competence question. What would be the appropriate legal basis in the treaty to go for work-life balances? Do we need to focus it inside Article 153, or should we basically go to the treaty article on gender equality?
Are there any other questions? I'm mindful that we should go for lunch, but I just have a really quick one to Nicole, because you said at the beginning that you would end with Brexit, and I wondered if some of your optimism around the social pillar had to do with Brexit, or not.
Well, I know exactly what the point that you're making. Yes, I mean, does it make it more feasible? Does it make it more possible that this will succeed if the UK are outside? That's the point that you're...
I mean, yeah, partially, but then there's Poland on the other hand. But I was just curious
how
you wanted to bring up Brexit.
Well, I didn't really want to bring Brexit into. I should say I'm here from Scotland, where we're not Brexiting.
Okay. I thought I heard.
Well, Brexit, I think, just as part of that kind of crisis,
political,
the political context. Yeah, I don't. Is it going to have an impact either way on what happens next? Given the timescales, given the uncertainty about Brexit, I wouldn't really like to predict anything actually on that score.
And don't forget, the UK may be very difficult during the interinstitutional negotiations on gender equality, for instance. They have been very helpful to get a number of things across. They may come up with the most awkward examples nobody ever thought about in other member states. And they may have lots of working time, but they were very helpful in getting equality things back on the agenda. Due to the fact that domestically they have a very legal framework.
Yeah, and I think the court
Don't
is now
forget it, don't blame everything on
nothing else.
And in fact, I think maybe Poland would be much more problematic because they're doing, the current administration is doing its own work-life balance policy. They're actually, the current Polish administration has been quite worker-friendly in some aspects, but they're doing it in a really traditionalist way that goes very much against what even this proposed directive is trying to do. So it's quite problematic. Well, thank you very much. Please join me in thanking the panelists.